Hello and welcome to this special discussion on the developments surrounding the Citizenship Amendment Act. Well, the Supreme Court today has made a very specific observation. It has said that the situation in Assam and Tripura are different, hence cases and anti-CAA pleas pertaining to these states should be held separately. And this is a massive development, even as the Supreme Court has refused to put a stay on the Citizenship Amendment Act for now. But this can be seen as a major victory for the anti-CAA groups in the region, especially Assam and Tripura, because the court has observed that anti-CAA petitions from these states need to be handled separately. As such, Chief Justice S.A. Bobde has said that there would be separate hearing for CAA pleas from Assam and Tripura. In fact, the CJI also said that all cases from Assam and Tripura will be listed separately under one category. Of course, this is a big development, as for the first time it has been acknowledged that the protests in the region are different in nature from the rest of the country and hence need different handling. Meanwhile, the Supreme Court has given 4 weeks' time to the centre to respond to the CAA pleas, but as far as Northeast, as far as Assam and Tripura is concerned, the Supreme Court has asked the centre to file reply to the petitions in only 2 weeks' time. So clearly an urgency of sorts visible there. Now the question that we are asking here today is that can this be seen as a first victory for the anti-CAA groups in the region as far as their fight against this act is concerned? Before we go ahead with the discussion, let's listen in to the advocate after the Supreme Court hearing, and also to ASU Chief Advisor Samujal Bhattacharya.
আজি কেছটো আমাৰ কনষ্টিটিউশ্যন বেঞ্চতো যোৱাৰ ফুল চান্স আছে। কোৰ্টে কৈছে যে দে উইল কনষ্টিটিউট এ বেঞ্চ, চেম্বাৰত এতিয়া মাতিব, বিকজ লেড বাই ফিউ ছেগ্ৰিগেট পাৰ্টিজ, যেনেকৈ বেংগলৰ বেলেগ, অসমৰ বেলেগ। অসমৰ হোপফুলি বিকাশ সিং ছাৰে থাকিব, লগত থাকিম আমি, আৰু তেওঁক প্লেচ কৰা যাব। কোৰ্টে সুধিব কি কি সুধিব লগা আছে, চেম্বাৰত বেলেগকৈ এটা ডিছকাশ্যন হ'ব। অসম আৰু ত্ৰিপুৰাটো যিমানখিনি কোৰ্টে কৈছে সেইটো তেওঁলোকে বেলেগকৈ শুনিব। তেওঁলোকে লিষ্ট খুজিছে, আমি লিষ্ট দিছোঁ, আৰু সেই লিষ্টখিনি অসমৰ কাৰণে বেলেগকৈ শুনিব কোৰ্টে। 4 সপ্তাহৰ টাইম দিছে কোৰ্টক। বহুতখিনি প্ৰেছ কৰা গৈছিলে কোৰ্টক ইণ্টাৰিম অৰ্ডাৰ দিয়াৰ কাৰণে, কিন্তু কোৰ্টে কৈছে যে 4 সপ্তাহত ইমানখিনি ইমপ্লিমেণ্ট হ'ব নোৱাৰিব। সেইটো কাৰণে 4 সপ্তাহত তেওঁলোকেতো 8 উইকছ টাইম খুজিছিলে, কিন্তু কোৰ্টে কনচিডাৰ কৰিলে যে 4 সপ্তাহে দিব লাগিব, কনচিডাৰিং দ্য আৰ্জেঞ্চি অফ দ্য মেটাৰ। আৰু উইদিন 4 উইকছ তেওঁলোকে ফাইল কৰাৰ পিছত কোৰ্টটো 5th উইকত আমাৰ মেটাৰটো লিষ্ট হ'ব। 5th উইকত এতিয়া একেলগে আহিব মেটাৰখিনি, কিন্তু অসমৰটো বেলেগকৈ শুনিব বুলি কোৰ্টে এচিয়ৰেঞ্চ দিছে।
অসম ত্ৰিপুৰা বেলেগকৈ শুনা হ'ব আৰু ৰেষ্ট অফ দ্য
য়েছ, অনলি অন দ্য বেচিছ, বিকজ অসম আৰু ত্ৰিপুৰা দুটাতে একৰ্ড আছে। অসমত 1985 যিটো একৰ্ড আছে, 66 আৰু 71 ইছ্যু কাট অফ ডেট লৈ পেলাই, সেইটো অলৰেডি কনষ্টিটিউশ্যন বেঞ্চত ৰেফাৰ আছে কাৰণে সেইটো কনচিডাৰ কৰাৰ কাৰণে অসমত বেলেগকৈ শুনিব। এতিয়া অসমৰ শুনানিও একেলগে হ'ব। কথাটো এইটো হৈছে যে অল দিছ মেটাৰ উইল কাম টুগেডাৰ, বাট তেওঁ বিচাৰিছে এটা লিষ্ট বিচাৰিছে ছেগ্ৰিগেট কৰাৰ কাৰণে। হোপফুলি হি উইল পাছ ছাম অৰ্ডাৰ ইনচাইড কনষ্টিটিউশ্যন বেঞ্চ ক্ৰিয়েট কৰে, বিকজ সেইটো তেওঁৰ লুক আফটাৰ হ'ব তাৰপিছত। আৰু সেইটো কাৰণে তেওঁ কৈছে যে আমি পিছত কিবা ইছ্যু সুধিব লগা থাকিলে অন দি স্পেচিফিক টেকনিকেল ইছ্যুজ হি উইল কল ফৰ দ্য ছাম অফ দ্য চিনিয়ৰ মেম্বাৰ্ছ এলং উইথ দ্য জুনিয়ৰ।
And to carry the discussion forward, I am being joined by NASO Chairman Samuel Jirwa from New Delhi. In Shillong, I have COMSO Chairman Robert June Kharjareen with me. And in the studios, I have BJP spokesperson Pramod Swami and ASU Executive Member Utpal Sharma. A very warm welcome to all of you to this special discussion on Northeast Live. I'll go straight to Samuel Jirwa, NASO Chairman. Samuel, the Supreme Court has today said that cases pertaining to CAA pleas, pertaining to CAA, which have been filed from Assam and Tripura should be put in one category and should be heard differently, separately. Do you see this as the first major victory, especially for groups like yours, the NESO, the ASU, and everybody else who have petitioned against the constitutional validity of the CAA? Do you see this as the first victory?
Well, you see, we wouldn't take it that way, but segregation of Assam and Tripura is a recognition by the Supreme Court of India that the cases of Assam and Tripura and also the Northeast is different from the plea of different pleas petitions from the different parts of India. And this is also a recognition that in Assam we have the historic Assam Accord, and also in Tripura they have the Tripura Accord. And this petition by NESO and also by ASU is on the ground that the CAA, it dilutes and it the historic Assam Accord of Clause 5 of the historic Assam Accord, and it infringes upon the Assam Accord in which the Government of India is itself a signatory. So we feel that the Supreme Court of India, by segregating the cases of Assam and Tripura and also to hear them first, which is very important, is a recognition of the historic accord that Assam and Tripura have with the Government of India.
Absolutely, absolutely. I would like to take that same question to Utpal Sharma of the ASU. Utpal, the ASU has been leading a long protest against the CAA, and of course there were hopes, in fact when we spoke to some of the top ASU leaders yesterday, there were hopes that the Supreme Court would go ahead and put a stay on the CAA, but that was very much unlikely, let's be practical. But do you see the developments today as something positive, something that organization like yours could look forward to?
No, at the very outset, we would like to welcome the decision of the Supreme Court to segregate the matters of Assam and Tripura from the rest of the country and to hear it differently. It was very much needed because the plea of ASU was itself that the situation in Assam is quite different. We have this Assam Accord. We have already taken the additional bargain of 23 years of migrants on behalf of the entire country. So we should not be imposed with the burden of any more illegal Bangladesh in a small state like Assam. This was our firm demand, and Supreme Court today recognized that demand, and Supreme Court decided to hear it differently. And as Samuel Jara has said, that first hearing would be made on behalf with regards to Assam. For the rest of the country, Government of India is given 4 weeks of time, but in Assam, to hear the case of Assam and Tripura, government is given only 2 weeks of time. And there is a very significant remark on behalf of the Supreme Court that it expects the Government of India not to take any initiative to implement this act within these days. Although it has not issued a stay order, but it has given a very significant remark that Government of India will not take any measure to, it expects that Government of India will not take any measure to implement this issue. And we believe now the ball is in the court of the Government of India, and it will show regards to the expectation of the Honorable Supreme Court of India.
Well, point taken. If I can go to Robert June Kharjareen in Shillong. Robert June Kharjareen, of course, the Supreme Court today decided to segregate anti-CAA pleas from Assam and Tripura to be heard separately because these two states have a unique history in terms of some accords signed. What about Meghalaya? Do you think that your state government is working in the right earnest to still ensure that Meghalaya will be exempted from the CAA?
I think first of all, I think we all are aware of the facts that as far as Meghalaya is concerned, the tribal area in the state under the 6th schedule to the Constitution of India is already exempted. So there are a few areas which has not yet exempted, and we are hoping that the entire state of Meghalaya will be exempted from the application of the CAA entirely. So from our side, we welcome the step taken by the Honorable Supreme Court of segregating the matter of CAA of Assam, Tripura, and Northeast from the rest of the nation, because you have seen that the issue that the indigenous people of Northeast are raising and the issue that raised by different part of India is totally different. For us, it's an issue of identity, it's an issue of protection and preservation of our identity. But from the other point of views, it's more or less a question of law of violating Article 14, Article 25, and another issue of violating the secular aspect of the Constitution of India. Even though we expect more than this, but of course, yes, it's a welcoming step taken by the Honorable Supreme Court, and we do hope that in a matter of 2 to 3 weeks, CAA will not be implemented in the entire Northeast as a whole.
All right, if I can come to Pramod Swami of the BJP in the studios. Pramod Swami, अब तो सुप्रीम कोर्ट ने भी ये एक तरह से मान लिया है जो अर्जेंसी है नॉर्थ ईस्ट में, जो अर्जेंसी है रीजन में, स्पेशली असम में इतना जो प्रोटेस्ट चल रहा था, तो हालांकि फॉर द रेस्ट ऑफ द कंट्री 4 वीक्स का टाइम दिया गया है टू द सेंटर टू फाइल द रिप्लाईज फॉर असम एंड त्रिपुरा, जो सुप्रीम कोर्ट ने सेंटर को कि आप 2 हफ्ते के अंदर जो है रिप्लाई फाइल कीजिए। तो सुप्रीम कोर्ट भी अब ये जाहिर सी बात है कि मान रही है कि यहाँ पे सिचुएशन अलग है। इसमें आपके पार्टी का अब रुख क्या रहेगा?
ऑन द सीए ये बात तो क्लियर है कि ऑल इंडिया में जो का को लेके जो मूवमेंट हो रहा है और आसाम में जो मूवमेंट हो रहा है, उस मूवमेंट में अंतर है। अंतर ये है कि सबसे पहले तो मैं व्यक्तिगत तौर से ऑल आसाम स्टूडेंट यूनियन को धन्यवाद देना चाहूँगा कि शुरू में 2 दिन जो अराजकता की स्थिति थी पूरे आसाम में, उस पर आशु के परिपक्व नेतृत्व ने पूरी स्थिति को बहुत अच्छी तरह से नियंत्रण किया और गणतांत्रिक रूप से ये अपना प्रतिवाद कर रहे हैं, जो कि उनका अधिकार है। अब सुप्रीम कोर्ट इसमें क्या निर्णय देता है और इसको अपने अपने तरीके से हर लोग व्याख्यात कर रहे हैं, इंटरप्रिटेशन कर रहे हैं, वो सबका हक है। तो हमें अपेक्षा करनी पड़ेगी कि सुप्रीम कोर्ट इस पर क्या निर्णय देता है। और यहाँ की जो ऐतिहासिक पृष्ठभूमि है उसको देखते हुए केंद्र सरकार ने इसके पहले भी ILP के जो क्षेत्र है, जहाँ इनर लाइन परमिट है, जहाँ 6 शेड्यूल है, उन एरिया को हमारे नेतृत्व में भी आसाम की और नॉर्थ ईस्ट की विशिष्ट पहचान को देखते हुए
आसाम की बात करते हैं। हम यहाँ पे
अलग रखा
है। नॉर्थ ईस्ट तो खैर अगर हम दूसरे स्टेट्स को, मेघालय को ले लेना,
आसाम में भी जो 6 शेड्यूल एरिया उसको हमने छोड़ा है।
नहीं, ठीक है, बट क्या आसाम में जो 6 शेड्यूल एरिया है वो काफ़ी एक तरह से एक छोटा हिस्सा है आसाम का। बाकी आसाम का क्या? आप सुप्रीम कोर्ट ही मान रही है? जी हाँ, आसाम में सिचुएशन डिफरेंट है, इसलिए हम कह रहे हैं कि इसको अलग से सुना जाए।
सुप्रीम कोर्ट का निर्णय आने दीजिए। अभी
हम निर्णय में टिप्पणी नहीं कर रहे हैं, ना ही हम कोई स्पेकुलेशन कर रहे हैं। कोर्ट के स्टेटमेंट के ऊपर हम कोई टिप्पणी कर भी नहीं सकते।
देखिए ऐसा है कि यहाँ जो लोग हैं उनको इस बात का खतरा है कि हमारी भाषा, हमारी सभ्यता, हमारी संस्कृति, हमारी परंपरा, जो एक बहुत विशाल परंपरा है असम की, उस पर खतरा उत्पन्न हो सकता है। तो अब ये सारी बातें अभी एक दिन में डिसाइड नहीं होगी, क्योंकि इस तरह का इंटरप्रिटेशन किया गया है कि 2 करोड़ आएंगे, 1 करोड़ आएंगे और वो पूरी सभ्यता, यहाँ की जो भाषा संस्कृति को खत्म कर देंगे। तो अब जब मैं यही कह रहा हूँ कि कितनी संख्या होगी, क्या वो जो संख्या होगी वो यहाँ की भाषा संस्कृति
हम बिल्कुल एड्रेस करेंगे, हम बिल्कुल एड्रेस करेंगे। इस मुद्दे पे हम आएंगे। उससे पहले इफ आई कैन गो टू सैमुअल जिरवा वंस अगेन। सैमुअल जिरवा, द सुप्रीम Court, while has said that for petitions pertaining to the rest of the country, the centre may take 4 weeks to file the reply, but in case of Assam and Tripura, it has said file the reply to the petitions within 2 weeks. Clearly, even the Supreme Court has recognized in a way the urgency of the situation in the region. Do you think the centre will be able to do justice to that 2-week time given to it by the Apex Court to file the replies? Samuel Jirwa.
Well, we hope that the government of India will comply with the order or the direction given by the court, in which to reply within 2 weeks for the different cases of Assam, and also within 4 weeks to the different petitions in which the court has received against this CAA. And again, we feel that with these developments, we have full faith and very hopeful that we will get justice from the Honorable Supreme Court of India.
Now, Utpal Sharma. Again, it is amply clear that the Supreme Court also by now recognizes that the situation in the Northeast is different. The protest in Assam is far different from what we have witnessed in Delhi, Lucknow, Kolkata, Hyderabad, and Bangalore, Chennai, everywhere else. But at the same time, there are also pros and cons to things. Now that the centre has been given 2 weeks time to file a reply, do you think organizations like yours, organizations who have moved the Supreme Court on the issue, have enough in your kitty to really prove your point to the Apex Court as and when the time comes that Northeast Assam should be exempted from the CAA? Because I'm sure even the government of India will come up with some valid reasons on why it should be implemented.
No, the petition that has been filed by the All Assam Students Union and the Northeast Student Organization, this petition very clearly depicts the situation in Assam and Northeast. It is different from the rest of the country. In most of the parts in the rest of the country, the movement is because of non-inclusion of Muslims. But in Assam and Northeast, the situation is different. We have already the threat of being reduced into minority in our own soil due to large-scale illegal influx of Bangladeshi nationals. So the Supreme Court today in a way has recognized this demand and has agreed to address the issues of Assam and Tripura separately. So we welcome this decision. At the same time, mass movement have been continuing. It's been more than a month when the CAA has been passed and this protest has been going on in the streets. Now as the matter is in the court, we will accept any decision that is given by the Honorable Supreme Court of India. But until the decision comes, the mass movement throughout the state will be continued.
But again, Pramod Swami, would you like to respond to that? Because the centre has been saying we will implement clause 6 to the letter and spirit and that will be a protection for the indigenous people of Assam. बीजेपी इस चीज़ को कैसे, जैसे बार बार आप ये प्रेजेंट कर रहे हैं, आप असम के लोगों को कह रहे हैं कि हम क्लॉज 6 लाएंगे, आप जो इंडिजिनस हैं उनकी हर राइट्स को प्रोटेक्ट की जाएगी. बट जो ऑर्गेनाइजेशंस और लोग जो प्रोटेस्ट कर रहे हैं सीएए का, उनका ये कहना है कि हमें एक भी विदेशी नहीं चाहिए. उस चीज़ को आप कैसे एड्रेस करेंगे? वेरी शॉर्ट.
देखिए, आसाम एकॉर्ड की जो आत्मा है वो 6 नंबर क्लोज है. 6 नंबर क्लोज में जो है कॉन्स्टिट्यूशनल सेफ गार्ड देने की बात कही गई है और 1985 में आसाम एकॉर्ड हुआ. लेकिन इसके पहले जो भी सरकारें थी उन्होंने इस दिशा में कोई ठोस कदम नहीं उठाए. लेकिन हमारी सरकार आने के बाद में हमने जस्टिस बिप्लब शर्मा के नेतृत्व में एक कमेटी का गठन किया है जिसमें आसू के मेंबर्स भी उसमें मेंबर्स हैं और वो लोग प्रतिवेदन देने के कगार पे हैं और वो प्रतिवेदन जब देंगे तो 6 नंबर दफ़ा को हम लोग इम्प्लीमेंट करके जो इंडिजियस लोग हैं उनकी जो कॉन्स्टिट्यूशनल राइट है उसको हम लोग इंश्योर्ड करेंगे. तो ये इस बात का प्रमाण है कि भारतीय जनता पार्टी जो कहती है वो करती है. हम जो वादा करते हैं उस वादे को हम निभाते हैं. तो इससे आसाम की जनता का एक विश्वास भारतीय जनता पार्टी के ऊपर में और बढ़ेगा. दूसरी बात ये है कि ये का को लेकर के जो मूवमेंट जो चल रहा है, अगर गणतांत्रिक रूप से अहिंसात्मक रूप से अगर कोई प्रतिवाद करता है तो हमें उस पर कोई आपत्ति नहीं है, क्योंकि ये हर राजनीतिक दल का और हर सामाजिक संगठन का और हर संगठनों का ये संवैधानिक अधिकार है कि वो अपनी बात को सरकार से सहमत हो या असहमत हो, वो अपनी बात को जनता के सामने रख सकते हैं. तीसरी बात मैं यहाँ ये कहना चाहूँगा कि जो संख्या मैंने पहले भी कहा कि एक परिसंख्या असम के लोगों के सामने रखी गई कि 1-2 करोड़ लोग आएंगे और यहाँ की भाषा, सभ्यता, संस्कृति को ख़त्म कर देंगे. तो अब ये चीज़ अभी मैं बोलूँ कि 2 लाख आएंगे, 5 लाख आएंगे, कोई 2 करोड़ बोल रहा है, तो ये तब तक ये बात क्लियर नहीं होगी जब तक कितने लोग अप्लाई करेंगे. उसके बाद में ये संख्या जब सामने आ जाएगी तब हम इसको सही रूप से इसका विश्लेषण कर सकेंगे कि क्या इतने आदमियों से हमारी भाषा या संस्कृति खत्म हो रही है क्या
तब तक वेट करेंगे, तब तक वेट करना. अब देखिए मैटर सब जुडिस है, सो इस मामले में हम कुछ कहना नहीं चाहेंगे.
कोर्ट तो अपना निर्णय देगा, कोर्ट को इससे कोई मतलब नहीं है और कोर्ट जो सुप्रीम कोर्ट जो निर्णय, महामान्य अदालत जो निर्णय देगी वो हम सबको स्वीकार है.
उत्पल शर्मा, you have a point to make.
It has been said for the last few days that clause 6 is the soul of the Assam Accord. If at all there is any soul of the Assam Accord, that is clause 5 actually. After clause 5, the clause 6 comes. Clause 6 is guaranteed to the indigenous people of Assam for taking the burden of additional migrants of 23 years. That is from 1948 to 1971. When in rest of the country, the cutoff year is 1948, 19 July. We have 24th March 1971. This is for this period of illegal migrants that we have taken. If we have been given the burden of additional 43 years of illegal migrants up to 2014, 31st December, then clause 6 and constitutional safeguard cannot protect the interest of the people of Assam. That is very much clear.
So what is the way forward? In fact, I would like Robert June Kharjarin to come in here. Robert June Kharjarin, does it mean, as we all know, the Meghalaya government is pursuing the ILP issue with the centre. If ILP is implemented in Meghalaya, do you think it is as good as exemption from the CAA?
You see the clause which has been incorporate in CAA 2019, it's clearly mentioned that the provision of CAA will not be implemented in the state where ILP is enforced. So the moment Bengal Assam Frontier Regulation is implemented in the state of Meghalaya, that in itself will ensure that CAA is exempted. Why we are always demand for ILP? Because mere exemption of CAA from the state will not be enough until and unless we have a system or a legislation which prevent the influx of the new influx of immigrants to our state. Exemption will is good, but the spillover from other non-exempted state will still be there into the state of Meghalaya. So that's why if ILP is implemented into the state, it will be a big relief to the state of Meghalaya. As firstly, it will ensure total exemption from CA, and second, this in itself will act as a regulation to prevent new immigration into the state of Meghalaya, and at last it will ensure for the protection and preservation of the identity and the right of interest of the indigenous people of the state of Meghalaya.
So as far as Meghalaya is concerned, what our pressure groups, CSOs feel that once ILP is implemented, it is as good as being exempted from CA. So ILP, according to the groups and certain CSOs, is the solution as far as Meghalaya is concerned, whereas it may not be the same as far as Assam, if we talk about Assam. But before we go into that, Utpal Sharma, let me quickly go back to Samuel Jirwa, who is in Delhi, who is joining us from Delhi. Samuel, as we all know, the centre has been asked to file the reply to petitions on the CAA pertaining to Assam and Tripura within 2 weeks. Now coming back to the entire process, do you think, the same question that I asked to my friend from ASU here, do you think the NESO, the ASU group like yours have enough arsenal in your kitty to impress upon the apex court that by under no such circumstances should the CAA be implemented in the region?
Well, you see, in our petitions, it's very simple, that this CAA is unconstitutional, the CAA is communal, and the CAA is anti-Northeast, the CAA is against the interests of the indigenous peoples of the Northeast. We want the court to recognize of the magnitude of the unregulated influx from Bangladesh, in which it has changed the demographic structure of most of the states of the northeastern region, especially Tripura and Assam. And we also hope that the court will give due recognition to this menace in which the indigenous peoples of Northeast have been facing since 1947 till the present day. And we hope that the court will take due recognition by giving remedial measures to stop this menace, to stop this unregulated influx into the different states of the northeastern region. And we hope that through the intervention of the court, we've been saying to the government of India to save Northeast today in order to save India tomorrow. So we hope that with the kind intervention of the court, we will be able to save the indigenous peoples of the whole of the northeastern region, especially
save
in
Northeast
Tripura
today,
and in Assam.
Save Northeast today to protect India tomorrow. Utpal Sharma, we are running out of time. Your last remarks. It seems very unlikely that the government of the day and the anti-CAA organizations will be on the same page ever. Are we looking at a battle till the end?
No, we have lost all hopes on the government. Last faith, and we have firm faith on the Honorable Supreme Court of India that it will impart justice upon the people of Assam. Till then, we would like to appeal to the indigenous people of Assam and Northeast to carry on the non-violent, disciplined and democratic movement until and unless this CAA is scrapped and the rights of the indigenous people are protected.
Pramod Swami, last comments, last remarks.
देखिए, इस पे सुप्रीम कोर्ट जो है अपना निर्णय देगा समय के अनुसार, और सुप्रीम कोर्ट के निर्णय का सबको स्वागत करना चाहिए। और इसके अलावा भी मैं ये कहना चाहूँगा कि बातचीत के दरवाजे बंद नहीं होने चाहिए। जो भी आंदोलनकारी संगठन है और जो हमारी सरकार से भी मैं निवेदन करूँगा कि इस विषय में समय पर बातचीत के दरवाजे खुले रखने चाहिए, जिससे अगर बातचीत के द्वारा भी किसी समाधान तक हम पहुंचे तो हमें उस समाधान तक पहुंचने का प्रयास करना चाहिए.
Talks should go on. The court will take its decision in due course of time. One thing is certain: the groups from the region who have been opposing the CAA have definitely got a boost today after the Supreme Court decided that cases pertaining to as far as Assam and Tripura are concerned should be heard separately. It will be interesting to see how things shape up when the centre files its reply to the petitions 2 weeks from now. That's a wrap of this show. Thank you all the panelists: Samuel Jirwa, NESO Chairman, who joined us from Delhi, Robert Jun Khajareen, Pramod Swami, Utpal Sharma.